was not going to be available today. She has sent her son, Mr. Gilling, to stand in for her. Yes, Mr. Gilling.
Worship, I confirm I'm just standing in for Mr. Gilling.
Thank you, Worship.
Received the statements, replying statements in respect of applicant number 1, number 3, and number 5, and their cases were closed. Am I correct, Mr. Chair?
Yeah, that is correct, Worship.
Correct.
Correct, but there is a development on Thursday. There is a notice to amend by applicant number 1 and 5 by deleting certain paragraphs in his reply, and then the application to amend and add a paragraph in respect of applicant number 5. Your Worship, the notice I'm giving to understand is attached to the charge sheet. It was filed with the criminal court clerks on the 4th of April and served on all the parties on the same day.
Not attached to the charge sheet. And I see your colleagues are throwing their hands, indicating that if I understand the body language, that they were not served. Mr. Volmarans?
Your Worship, I was talking to my learned.
Oh, okay. Then I misunderstood.
No, we were served as a state.
You were served?
Yes, we were served as a state.
Any objection?
No, Your Worship, except that as per the proper procedure, they have to reapply for opening of their case. We have no objection in respect of that.
Mr.
You should be in light of the fact that the court is unable to find a copy attached to the charge sheet. Can I hand up our copy? It would appear that the criminal court clerk who received and issued out is P. Subramani. With the leave of the court, if I may hand up the copy of the notice to amend.
#24, although there is no date stamp. Yes.
Your Worship, my learned colleague for the state has placed it on record that there is no objection. It is my humble submission that it's against that background that on last week Thursday, the instructing attorneys had to follow the procedure to file a notice informing all the interested parties in the matter that the intention is to amend and supplement. With the leave of the court, can I make an application that replying affidavit for accused number 5 was accepted as Exhibit H, and for accused number 1, Exhibit H, accused number 5, Exhibit K.
But Mr. Lawyer, should you not first start by applying to reopen your case or the case for your respective clients because they've already been closed?
As court please, Your Worship, I am making an application before this honorable court to reopen so as to amend. The reason, Your Worship, is that as the replying affidavits were drafted in a hurry, it would appear that there was a mistake between the instructing attorneys and the accused, the applicants, which was brought to the attention of the instructing attorneys, which had to be corrected by timelessly filing the necessary papers and inform all the parties so that if there is objection, that objection can be a substantive application could be made. That is all, Your Worship.
This is an application to reopen the applicant's case, applicants being applicant number 1 and applicant number 5.
That is the position, Your Worship.
Mr. Twega?
From the respondent side, there's no objection, Your Worship.
No objection. Mr. Volmarans?
No objection, Your Worship.
Thank you. You may proceed, Mr.
Please, Your Worship, if the affidavit for the first applicant can be, the supplemental can be accepted as K1, and then, apologies, H1 and K1, respectively.
In respect of applicant number 1, it would be H1. And in respect of applicant number 5, it would be K1.
As the court pleases. If I may hand up the original so that the court can follow.
Thank you. You may proceed.
As court pleases. In the Magistrate Court for the District of eThekwini held at Durban, case number 23/2156 of 2024, in the matter between Lindokuhle Thabani Mkhwanazi, first applicant Lindani Zenzele Shisela Ndimande, second applicant Siyanda Edi Mieza, third applicant Mziwa Themba Harvey Kwabeni, fourth applicant Lindokuhle Lindo Demande, fifth applicant and the state the respondent. First applicant's supplementary replying affidavit in support of application for bail. I, Lindokuhle Thabani Mkhwanazi, the undersigned, hereby state under oath and submit the following. Paragraph 1. The facts which I depose are within my personal knowledge unless otherwise stated or the context so indicates. The propositions of law herein are advanced on the advice of those representing me. 2. I refer to my replying affidavit dated the 2nd of April 2024 and my notice to amend dated the 4th of April 2024. Upon consultation with my legal team, I hereby wish to supplement and clarify certain admissions of my initial replying affidavit. 3. Paragraph 7.4 of my initial replying affidavit reads as follows. The investigating officer alleges that he and his team came across some social media platforms showing me brandishing a rifle and showing off with it. He further states it as a fact in this paragraph that he and his team do not have any document indicating that I have a valid license for this firearm. I pause to assert that this version is a lie. The investigating officer got this version from his informer, took it as a gospel truth from the informer, never verified it through investigation, and took a risk of stating it as a fact under oath by exposing himself to the criminal offenses of perjury and defeating the cause or ends of justice. 3.1. I hereby wish to amend this by deleting and supplementing this paragraph to read as follows. A. The investigating officer alleges that he and his team came across some social media platforms showing me brandishing a rifle and showing off with it. He further states it as a fact in this paragraph that he and his team do not have any document indicating that I have a valid license for this firearm. I pause to assert that the investigating officer did not verify the identity of the individual in the image is in fact myself, or in what capacity the firearm was being used. For interest's sake, I also wish to say that I have the following competencies as set out below. Paragraph 4, I hereby wish to delete paragraph 7.6 and 7.7 of my initial replying affidavit dated and signed at Durban on this 8th day of April.
Do you confirm the content of this statement, Mr. Mkhwanazi, applicant number 1?
This statement is novela kubhalwe phansi yakwazi ukuyiqinisa.
Yes.
I confirm same to be correct, Your Wish.
Statement already accepted into the record. It's handed in. It's marked Exhibit H1.
As court pleases. I'm indebted to the court. In respect of K1, Your Worship, in the Magistrate Court for the District of eThekwini, held at Durban, case number 23/2156 of 2024, in the matter between Lindokuhle Thabani Mkhwanazi, first applicant, Lindani Zenzele Shisela Ndimande, second applicant, Siyanda Edi Mieza, third applicant, Mziwa Themba Harvey Kwabeni, fourth applicant, Lindokuhle Lindo Ndimande, fifth applicant, and the state, the respondent, fifth applicant, supplementary replying affidavit in support of application for bail. I, Lindokuhle Lindo Ndimande, the undersigned, hereby state under oath and submit the following. Paragraph 1. The facts which I depose are within my personal knowledge unless otherwise stated or the context so indicates. The proposition of law herein are advanced on the advice of those representing me. Paragraph 2. I refer to my replying affidavit dated the 2nd of April 2024 and my notice to amend dated the 4th of April 2024. 2.1. Upon consultation with my legal team, I hereby wish to supplement and clarify certain submissions of my initial replying affidavit. Paragraph 3. Paragraph 4 of my initial replying affidavit reads as follows. I aver that I've seen the affidavit deposed to by the first applicant, and I wish to bring it to the attention of this honorable court that in equal measure, paragraphs 4, 5, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 19.1, 19.2, 19.3, 19.4, 19.5, 19.6, 19.7, and 19.8, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 42, 43, 44, 45, 46, 47, 48, and 49. 3.1. I hereby wish to amend this by deleting and supplementing this paragraph to read as follows. I aver that I've seen the affidavit deposed to by the first applicant. I wish to bring it to the attention of this honorable court that in equal measure, I concur with the submissions raised in his replying affidavit pertaining to the merits and facts. Paragraph 4. Paragraph 15 of my initial replying affidavit reads as follows. I do not dispute that for work I rendered without being paid over a period of time, that I was paid eventually 100,000 rand by the fourth applicant. The fourth applicant used to entrust me with the duty to be his driver, especially with his long trips, and sometimes there will be months in which I was not paid. 4.1. I hereby wish to amend this by deleting and supplementing this paragraph to read as follows. I do not dispute that for work I rendered without being paid over a period of time, that I was paid eventually 100,000 rand by the fourth applicant. The fourth applicant used to entrust me with the duty to be his driver, especially with his long trips, and sometimes there will be months in which I was not paid. I also received a payment of 33,000 rand for Izitole heifer cows from the fourth applicant, who instructed me to keep the cows at my homestead so that they may give birth to further calves that we would sell. Thus, I received a payment of 133,000 rand in total, dated and signed at Gavin on this 8th day of April 2024.
Mr. Ndimande, applicant number 5, do you confirm the content of this statement?
Statement sakho ndimandi besifundo umelo wakho manje ke uyaqinisekisa ukuthi uyakwazi ukubhala phansi kweqiniso. Confirm same to be correct, Your Worship.
Statement already accepted into the record. It's received and marked Exhibit K1.
Please, that is the case for both applicant number 1 and applicant number 5.
Case for applicant number 1 and applicant number 5. Mr. Volmerans. You and Mr. Jacobson came to see me in chambers. Who is for applicant number 2 and who is for applicant number
I'm for applicant number 2.
Oh, okay.
And my learned friend, Mr. Jorgensen, will be
Thank you.
on behalf of the accused.
Thank you. Are you ready to proceed?
Yes, Your Worship. May I hand to Your Worship the original? If I may have leave to read it into the record.
You may proceed, please. Thank you.
Thank you, Your Worship. In the Magistrates Court for the District of Durban held at Durban, case number 23/215/2024. In the matter between the state and LT Mkonazi, LZ Ndimande, ES Mnyeza, MH Kwabeni, and LM Ndimande, being the respective applicants 1 to 5. The replying affidavit of applicant 2, I, the undersigned, Zenzele Lendani Ndimande, do hereby make oath and state as follows. 1. I do not intend to deal with aspects already dealt with in my filing affidavit, but will confine myself to the relevant portions of Philo's opposing affidavit relating to me. I stand by my founding affidavit and what is stated therein. The state has employed every stratagem to prevent the applicants from using what is otherwise relevant evidence, in my view, such as the DPP E. Harrison's affidavit. The Honourable Court has now allowed it provisionally. One such objection raised by the state is the non-compliance with Section 235 of the CPA. The section refers to a record, which means the entire record, not merely portions which suit the state. The state has seen fit to hand in the so-called record of case number 23/11247/23, but only the affidavits attached to the charge sheet. The recorded portions of the record are absent. It is therefore incomplete. Although the front page bears a certificate of it being a true copy, I submit that it would have been impossible to check and compare each and every page to certify it in the short space of time allowed by the court. Perhaps the reason for using my affidavit was to show that although the affidavit states I had no passport, it is clearly a mistake on the part of the drafter thereof. I was aware that the police, in particular Maharaj, was in possession of my passport from the time of my arrest. Of greater concern to me in the use of those documents is the fact that I am aware that the record of bail proceedings is admissible against an accused at his subsequent trial. Among the documents is an affidavit by Maharaj detailing a statement which would be challenged at trial is inadmissible. I therefore humbly submit that the court should not allow the use of the documents in the manner that they are. These documents should only be used at my trial. The contents of the documents, if allowed in this bail application, are highly prejudicial to me. Again, in paragraph 185 of his affidavit, he refers to Berea Cas 53/3/2023 regarding statements allegedly made by me. Again, I state that this is a matter for the trial court to decide on its admissibility. This information is included here merely to prejudice me. It is also unacceptable that Maharaj is permitted to express his opinion regarding the existence or otherwise of exceptional circumstances. It shows disrespect to the court in attempting to influence the court by usurping the court's function. The fact that members of my clan or family elected to go to Eswatini for fear of their lives or any other reason is on them and cannot be attributed to me. The views of Maharaj and his team, as continually referred to, are irrelevant when made without proper foundation. I do not believe that it is necessary, as suggested by Maharaj, to give every single detail regarding my children. He is fully aware of my and my children's personal circumstances. This is, after all, my application for bail, not theirs. I pause to mention that Maharaj and the SABC records are incorrect, reflecting that I was sentenced to 15 years imprisonment for my last conviction. On appeal, my sentence was reduced to 10 years imprisonment, which sentence I have served, and I am therefore not on parole or under any other restriction. I refer to the assertion that I am connected to these crimes by cell phone records. In this regard, I refer to the statements of my co-applicants regarding the reliability thereof. Although it is stated I was not assaulted or tortured or threatened, I reiterate that what is stated by the investigators is untrue. I was subjected to assault, etc. after my arrest. According to the state's opposing affidavit, the evidence against me, which is found under the heading C, evidence against the applicant, at pages 21 to 22, appears to be cell phone records, evidence which is not elaborated on, that I gave instructions regarding firearms, that I received money. It appears that the state regards this as a prima facie case against me. It is not stated that the state have a strong case against me. This at best is circumstantial, which will be challenged at trial and probably relies on the section 204 of the CPA witness. Such witnesses are notoriously unreliable. In the face of a lack of direct evidence against me, I submit that the state case against me will not stand up to proper scrutiny. For this reason, I submit that I have discharged the onus placed upon me and that I have proved exceptional circumstances which justify my release in the interests of justice. I respectfully request this Honourable Court to grant me bail together with suitable conditions, bearing in mind the purpose of bail is not to act as a pre-conviction punishment but to ensure that I stand trial. I undertake not only to stand trial, as I have in the past, but also to abide any conditions that the court deems fit. It is dated and signed and commissioned on behalf of the accused.
Was it read to him? Does he understand?
It has been read to him and interpreted to him and can be handed in.
Mr. Ndimande, do you confirm the content of the statement?
He does, Your Worship.
Thank you. The statement is accepted, handed in marked Exhibit L. Mr. Volmarans,
As for the
case for applicant number.
applicant number 2.
Thank you. Mr. Jackerson.
Worship, I've been instructed to ask Your Worship for a stand down of approximately 5 to 10 minutes, just to make sure that all the affidavits are in order. My learned friends are furnished with the necessary copies.
5 minutes. You confirm?
No, nothing, Your Worship.
Court adjourns for 5 minutes.
The pleasures the court, your worship, state is recalling case number 23/2156 of year 2024, State versus Lindani Mkwanazi and 4 others.
Thank you. Thank you, Mr. Jorgensen.
For the indulgence, your worship, can I hand to your worship the original reply and affidavit of applicant number 4? Your worship will note that with that affidavit are confirmatory affidavits, as well as a USB from which the stills which are attached to the affidavit were taken. My learned friends for the state have been furnished with a copy of all that I've outlined to your worship.
We have received same.
May I?
You
Thank
may
you.
proceed. Thank you.
This is the reply and affidavit of applicant number 4. I, the undersigned, Mzwitemba Harvey Gwabeni, do hereby make oath and state. I've read the affidavit deposed to by Kumarasan Pillay and respond thereto as set out hereunder. My failure to address each and every allegation should not and must not be considered to be a tacit agreement on my part. It is not my intention to repeat what I've stated in my founding affidavit, but simply to address those aspects of Pillay's affidavit which I believe deserve attention. A critical reading of Pillay's affidavit should, I believe, lead the reader thereof to the conclusion that the state's case against me consists of the investigating officer taking bits and pieces of evidence which he believes is suitable to his case, joining them together with his own theories and thereafter presenting them to this court. In so doing, he has attempted to mislead this court and has departed from his duty as an investigating officer to investigate objectively by leaving out evidence favorable to me. The immense problem that the state has in this matter, and which can be described as the elephant in the room, is the status of Mfundo Gaba and the failure on the part of the state to arrest him. The state has alleged that I am the mastermind behind the killing of Kiernan Forbes, aka, and Tabela Mutswana, and that an amount of 800,000 rand, which was transferred into my account, was payment for the so-called hits. The state has alleged that the transferring of the funds was payment for the shooting. In this regard, paragraph 71 of Pillay's affidavit refers. According to company records, Mr. Sidney Mfundo Gaba is the sole director of this company. When the money was transferred, a reference was used as consult. This, we are of the view, was done to disguise the nature of the funds, as same is viewed to be payment for the shooting. If the state honestly believes this, and if it had any evidence, not conjecture, then I would have expected that Mfundo Gaba would have been arrested and would have been a co-accused. The fact that he is not a co-accused and the state has not taken this court into his confidence and disclosed why they have chosen not to arrest him. As I've stated in my founding affidavit, I'm involved in the coal mining industry and consult to various parties. The reference accompanying the deposit of 800,000 rand into my account, namely consult, is corroboration of this fact. It is not the function of this court to simply rubber stamp that which the state desires, and in fact the law, when it comes to bail applications, encourages a presiding officer to adopt a more inquisitorial manner. As such, I believe that the question this honourable court should be asking is why exactly has the state failed to arrest Mfundo Gaba? I submit the answer to the said question is because there is no evidence against him, save for the payment of 800,000 rand into my account for services that I rendered to him. Just as the state has been unable to tell this honourable court what possible motive I could have in the killing of Forbes, so it is, and that the state cannot inform this honourable court why Gaba would want Forbes and his companion killed. The reason for this is simple, and that is that neither of us are contract killers or wish to see them dead. I addressed those aspects of Pillay's affidavit that deserve attention hereunder. At para 9. Pillay alleges that I was at the airport and that I used my phone to pay for parking using a virtual bank card. If he had investigated properly and objectively, he would have noted that my wives and those who do work for me are also in possession of a virtual bank card linked to my account. A virtual bank card and the allegation that I was at the airport around the same time is simply insufficient. It is insufficient, and it is also based on cell phone triangulation, which at best puts an individual within a 10-kilometer radius of any particular object or building. The state has been strangely silent and has chosen not to address the fact that an airport is a national key point with extensive security and closed-circuit cameras. As such, had I been the driver of the grey BMW on the day and time in question, I would have expected the state to state categorically that they have video evidence of me driving the motor vehicle and following Forbes. The fact that they have not stated this is an indication that they have no evidence that I was driving the grey BMW or even in the said motor vehicle. As I've stated from the onset, it is no secret that I was in possession of the grey BMW as well as the grey VW Polo. It is alleged that, upon further investigation and using cellular phone records, it was established that applicant 4 was present in the grey BMW that had followed the first deceased and his entourage to the hotel. The state does not take this honourable court into its confidence and disclose the investigation, and its vague reference to cellular phone records can only but mean cell phone triangulation. This on its own is insufficient, and I'm advised that there is case law which comments critically upon the reliance of cell phone records. Ad para 18. Although the purpose of my deposing to this affidavit is not aimed at defending my co-accused, it is necessary to point out certain allegations which I believe are indicative of Pillay wanting to mislead this honourable court. An example of this is that the clothing of the person that alighted from the vehicle and entered the restaurant was the same as seen in the video footage as being the African male that was later identified as applicant 5. It is significant that Pillay does not describe the clothing other than a vague reference to it. An example of this is 2 individuals who both wear long pants and a long shirt. They would be seen to be having the same clothing, according to Pillay. Ad para 26. Another indication of this is the allegation that one of the suspects who attempted to set the Mercedes-Benz alight purchased airtime from a tuck shop a few meters from where the vehicle was abandoned. This honourable court is not informed as to the date upon which the Mercedes-Benz was allegedly attempted to be set alight, as well as the date upon which one of the suspects allegedly purchased airtime. Ad para 27. Once again, reliance is placed on cell phone triangulation, and the allegation is made that I was in the vicinity of Florida Road at the time of the shooting. Whilst I cannot recall my exact whereabouts, Florida Road is considered one of the premier night spots of Durban, with notable restaurants such as Zai, El Cubana and Duka. Importantly, Pillay does not share with this court exactly what he means by in the vicinity of Florida Road. And by that I mean nowhere in his affidavit does he state where the cell phone records place an individual 5 meters, 50 meters, 100 meters, 500 meters, or even 1,000 meters away from any particular spot. The investigating officer adopts a similar modus operandi in respect of other geographical places in which he relies on virtual cards without ever having investigated how many individuals were issued with the virtual card or how accurate the cell phone triangulation is. Instead, he prefers to rely on in the vicinity. Ad para 31. Once again, the state relies upon the fact that applicant 1, 2 and 5 were placed in the vicinity of my home on 11 February 2023. In this regard, I deny that they were with me, but I was most certainly at my home. I cannot comment on what applicant 1, 2 and 5 were doing or where they might have been. In this regard, it is significant that the other applicants have been charged with various offences in their own capacity or where they are linked to each other. That they knew each other and may have been participant in other activities, I am not in a position to deny, as I do not know. Importantly, I have not been charged with any other offence besides this one. This is significant in that Pillay has alleged that the applicants are a gang and are available for hire. This is not, even on the state's version, the evidence before this honourable court. Ad para 33. I note that Pillay has elected to attach a table, Annexure KP1, to his affidavit, rather than simply attaching the actual bank statements, which would give this honourable court a proper insight to the passage of monies into and out of my account. Ad para 38. Pillay once again jumps to conclusions when he alleges that I gave instructions for the disposal of the vehicle, referring to the grey BMW. This is a distortion of the truth in that I did not dispose of it in the sense of wanting it hidden, as Pillay wants this court to infer. at para 48. Yet another example of Pillay not wanting to take this honourable court into his confidence is his reference to the raiding of my home. He states, entry was gained in a lawful manner as usually used when looking for suspects in order to arrest. What does this mean? He does not take the court into his confidence and describe exactly what occurred, and that is that heavily armed policemen forcibly gained entry into my home, and this was unnecessary. In this regard, I annex here to marked GR1 video footage of the said raid. And Your Worship, I understand that that is in the USB attached to the brown envelope. The actions of the SAPS are particularly alarming when it is alleged that a member of the SAPS team apparently spoke to me personally on 26 February 2024. See paragraph 207. At paragraph 118, Pillay states that there is evidence suggesting that the applicants operated as a gang that were hired to kill people as hitmen. Yet again, he does not take this court into his confidence and disclose what that evidence is. But the fact of the matter is that although he mentions that the applicants are at present facing, it should be facing, Your Worship, 12 counts, I am not. Once again, he does not disclose to this court why he has not arrested Gaba, more especially in light of his theory that I was hired to kill people as part of a gang of hitmen. At paragraph 119, as stated herein above, yet another example of the vagueness and smoke and mirrors that the state has brought to this investigation and this application is the following statement on the part of Pillay. There is an element of evidence suggesting offences committed under gang-related activities. The state is collecting evidence to substantiate these charges. He does not explain what an element of evidence is, which suggests offences, but simply states that the state is collecting evidence to substantiate these charges. The inference to be drawn is that this is yet another theory lacking in evidence. Similarly, the statement that there is evidence suggesting that there were discussions falls into the same category. At para 136, the state has alluded to money laundering and the proceeds of crime in respect of the 800,000 rand. He also makes mention of the reference in the bank statement to consult or consulting. He appears to have lost sight of the fact that that would have been a reference that was given by the personal entity that deposited the money and not myself. Once again, if the state is so confident that these monies were for unlawful purposes and it was not for consulting, then the state must explain why they have not arrested the individuals who deposited the money. In this regard, I annex here to marked GR2, a statement issued by Mandla Gaba in respect of the said monies. As for the reasons given as to why the state opposes bail, the state alleges that I will endanger the safety of the public or will commit further Schedule 1 offences because I am the alleged mastermind and was involved in the planning, and that this is therefore indicative of someone who can pose a danger to the public. I am advised that what the law requires is a likelihood, i.e. the probability, and not whether one can, as opposed to the requirement of will or would. In respect of the allegation that if released on bail I will attempt to evade trial, the state relies upon the fact that they have no evidence that I pay towards the bond of the house I live in with my wife and children. It clearly has not occurred to them that often in a marriage, one spouse pays for certain expenses while the other pays for the remainder. It is untrue to suggest, as Pillay has, that my wives would be able to fend for themselves without financial support. In this regard, I wish to remind this Honourable Court that my second wife is a student, and as such, she is unemployed. Her studies and indeed her entire existence is financed by myself. In respect of my first wife, as mentioned, the bond payments may come off her account, but I pay for the remainder of the other expenses. Were it not for my financial contribution, she will have insufficient funds to pay for the bond and maintain my family. Although my first wife is a practicing medical practitioner, she is also furthering her studies, and this is another financial commitment which needs to be met. Previously, this Honourable Court had ruled that the statements I had made and my analysis of the content of the affidavit deposed to by Elaine Harrison, the Director of Public Prosecutions for KwaZulu-Natal, had to be struck out as the court ruled that her affidavit was not properly before it. On the last occasion that this matter was in court, the learned magistrate allowed that very same affidavit to be admitted provisionally on the basis that same had been obtained from social media. I now take the opportunity to comment thereon. I deal with the content of Harrison's affidavit hereunder. In paragraph 9, Harrison alleges that Linda Kushle Ndamande was residing at my residence. She wishes the court to draw the inference that he was residing there and then left to go to Eswatini. Whilst it is correct that he did stay in my outbuilding for a brief period, he left some time ago and certainly before the date of the shooting which led to the death of the deceased. It is my respectful submission that the state's case, certainly against me, is founded wholly on circumstantial evidence and manufactured coincidence. Mention is made of the deceased's entourage being followed by a grey BMW from the airport to the Hilton Hotel. It states further that upon further investigation of cellular phone records, it was established that I was present in the grey BMW. This is untrue. The airport and its vicinity is a national key point area, and as such there are numerous cameras. I challenge the state to provide video evidence that I was in the said grey BMW. Rather misleadingly, it is stated that it was also established that I had hired the grey Polo and that it was used as a spotter vehicle. I do not dispute that I hired a grey Polo with registration NUR 597782. I hired it from a rental company as it was needed for my business requirements. Unfortunately, this Honourable Court is not informed as to the fact that I hired the vehicle some 10 months before the deceased was killed. Prior to the 10 months, I had hired another vehicle from the same rental company. It is also significant that where the state relies upon cellular phone records to place individuals in certain vicinities, that at two of Durban's most popular areas are the main road in Mshlanga, where the restaurants are situated, as well as Florida Road and its vicinity. In respect of Linda Kushle Ndamande, it is alleged that he was a spotter. I have read in the media that it is alleged that he used his credit card in the Wish restaurant. As a result of this fact, it is alleged in paragraph 15 of Harrison's affidavit that he must have been the individual who got out of a grey Polo motor vehicle, no registration number given, because his clothing was the same as the individual later identified as Linda Kushle Ndamande. In essence, what has been alleged is that it must have been him who stepped out of the grey Polo, whereas there is no actual evidence to suggest that the person who alighted from the Polo was the same person who used his credit card in the restaurant. I wish to make it clear that I only comment on same because it is alleged that I acted in common purpose with my co-accused. I am therefore to an extent compelled to deal with some of the allegations pertaining to them. In paragraph 21 of her affidavit, she states that it was established that there had been an attempt to set a Mercedes-Benz alight by one of the suspects. She goes on to state that one of the suspects also purchased airtime from a tuck shop situated a few meters away from where the said vehicle was abandoned, and that investigations revealed that Sipa Mandla Ngobo was identified as the individual who recharged his phone with the airtime purchased from the tuck shop. There is no nexus between the individual who purchased airtime and the individual who attempted to set the vehicle alight, apart from the allegation of Harrison. In paragraph 22, Harrison makes the allegation that the cellular phone records obtained for Sipa Mandla Ngobo indicate that he was at the scene of the murder and communicated with me. Once again, it appears that the state is relying on circumstantial evidence, as there does not appear to be evidence of Sipa Mandla Ngobo in the Mercedes-Benz in question at the time of the murder. Once again, I remind this Honourable Court that the Chartwell Drive vicinity in the Mshlanga Rocks and Florida Road are considered Durban's nighttime entertainment areas. I am not in a position to recall whether Sipa Mandla Ngobo may have communicated with me on that day or not. If he did, it would most certainly not have been related to the killing of the deceased, and may in all likelihood have been related in my wishing to engage his services amongst others. I shall now deal with the allegation, certainly as stated in the media, that I received 800,000 Rand the day that the deceased were killed, and that I transferred 133,000 Rand to Linda Kushle Ndamande. Once again, the state is relying upon coincidence. The 800,000 Rand was paid to me by Bright Cycle in respect of consulting work that I had done. It is true that I did transfer monies alleged, as I had not paid the individuals concerned for some time, as the nature of my work is that supply of monies is not always constant and regular, but goes through lean months and prosperous months, so to speak. I annex here to my bank statement for the period in question, and this Honourable Court will note that the transfers are referenced. Included in that reference is wedding, as one of the individuals concerned was getting married, and I paid him an extra amount as a gift. I also wish to point out that I paid the individuals concerned over an extended period of time, and not just on that fateful day, as the state wishes everyone to believe. Finally, in respect of the case against me, the state has failed to allege any motive on my part for wanting both of the deceased killed. They are unable, despite all the circumstantial evidence and conjecture, to place a motive before this court. The reason for that is that I had no motive, because I played no part in the death of the deceased, nor would I. Yet again, the state speculates when it refers to the fact that I have allegedly hired bodyguards for my and my family's protection, and that therefore my life might be in danger. Aside from the fact that the use of the word might does not satisfy the required case law in terms of probabilities, the learned magistrate presiding in this application, when he ordered us to unmask on our first appearance, stated that the safety is not an issue. There is no evidence to suggest that I will evade my trial, and in this regard, I have voluntarily handed to the authorities my passport. Much is made of the alleged failure to hand my cell phone to the police. This is untrue. When I went to Ladysmith on business, I forgot my cell phone at home. When I was contacted and arrangements were made for me to report to the police, I did not return home but went to the police. I am of the belief that the cell phone was taken by the police who raided my property, as the said cell phone has not been seen since. The police were informed of this prior to my bail application commencing. I respectfully submit that the fact that I surrendered myself to the authorities is a clear indication. It states I would evade my trial, but obviously it should state I will not evade my trial if released on bail. The state has alleged that if I am released on bail, I will influence or intimidate witnesses or destroy evidence. I deny the allegation and point out that the state's case against me appears to be based solely on formal evidence, i.e. cell phone records and locality, as well as flow of money into and out of my account. I deny the allegation that Caleb Naidu feared for his safety and as a result handed me a copy of his statement. It is simply not true. Ad para 234. The allegation that my attorney, when offering to make a statement about the grey BMW, was devious and calculated is far-fetched and without foundation. I was informed that the BMW had been seized and that the police were investigating same. It is only natural that I, as a law-abiding citizen, would have approached the authorities in order to explain how I came to be in possession of the said BMW. The allegation made by Pillay in this regard is yet another indication of the fact that his affidavit is scarce on facts and big on opinion. I am given to understand that an investigation ought to be objective and constitutionally sound. Pillay has fulfilled neither of the criteria. Ad para 235. The allegation that I disguised the money paid for the hit as a consultation is wrong. The annotation that a company did transfer of money into my account would have been done by the sender and not the receiver. Once again, I must ask, does the state intend to arrest Mfundo Dlaba? As for the references to dividends, car repairs, buying cars and wedding things, I am fully entitled to use any reference I wish. The simple fact of the matter is that the reference to dividends was the reward or remuneration for the services that I utilized. Buying cars and wedding things was for applicant 1 who was due to get married on 26 February. The state has alleged that there is a likelihood that I will undermine or jeopardize the objectives and the proper functioning of the criminal justice system because I allegedly run a security company that is not registered with SURA. I do not run a security company in the sense that I provide a security service for third parties. As such, there is no obligation on me to register with SURA, nor for those individuals that I make use of. The state makes much of the fact that I hired applicant 4 as a bodyguard in circumstances where he was declared unfit to possess a firearm. In this regard, I have never provided arms for any of the individuals, nor have I utilized the term bodyguard. Ad para 253. In respect of my private licensed firearms, they remain in the safe in my house, and I made the said safe available to the police. I have nothing to hide. Ad para 258. The state alleges that the proceeds of crime were deposited into his company account on 11 February 2023 as part of payment for the killing of the deceased persons. I deny that this is so, but based on the state's own version and the submissions of Pillay, the allegation made is defamatory as against myself and, more importantly, Mfundo Glaba. As a consequence thereof, the SAPS either need to retract same or provide the evidence by arresting Glaba. The failure to do so can only but mean that they accept that the monies paid into my account were not for the purposes of a hit, but was a legitimate payment for the work done. In conclusion, I respectfully submit that I have addressed each and every allegation, and that some of the allegations made by the state have already been negated by third parties who at the same time corroborate what I have placed before this honourable court. I respectfully request this honourable court to grant bail in the amount which is deemed appropriate, as well as the conditions deemed appropriate. Then, Your Worship, there's just 3 annexes that I also need to read into the record, and which are capable of being read into the record, if I may.
You may proceed.
Thank you. The first one is dated 31 March 2024. It reads, for immediate release. Statement issued by Mandla Glaba on behalf of the Glaba family regarding Mfundo Glaba in an ongoing court case.
Let me get to that. I thought you were going to read the page immediately after the one. So you are skipping Precious Gwabeni, Yolanda Zondi statement. And
Sorry, Your Worship. I see that
Okay.
I have them in a different order. Would Your Worship prefer me to read them in the order that Your Worship has?
Okay, please.
Very well. So there's a confirmatory affidavit. First confirmatory affidavit reads as follows. I, the undersigned, Precious Bulelwa Gwabeni, do hereby make oath and state. I am an adult female medical practitioner. I am the first wife to applicant 4 herein. The contents of this affidavit falls within my personal knowledge and belief, both true and correct, save where the contrary appears from the context. I have read the affidavit deposited by Kumasaran Pillay and respond thereto as set out herein under. I depose to this affidavit in reply to the above mentioned. I have also read and heard the contents of the affidavits of Mzuatemba Harvey Gwabeni. I have read the above mentioned affidavit of Mzuatemba Harvey Gwabeni and confirmed the facts contained insofar as they relate to matters concerning me. Dated at Durban, signed on this day of April 2024. The second affidavit, confirmatory affidavit, Your Worship, reads as follows. I, the undersigned, Yolanda Zondi, do hereby make oath and state. I am an adult female, a law student at the University of KwaZulu-Natal. I am the second wife to applicant 4 herein. The contents of this affidavit falls within my personal knowledge and belief, both true and correct, save where the contrary appears from the context. I've read the affidavit deposed to by Tomatis and Pillay and respond thereto as set out herein under. I depose to this affidavit in reply to the above mentioned. I've also read and heard the contents of the affidavits of Mzuatemba Harvey Gwabeni. I've read the above mentioned affidavit of Mzuatemba Harvey Gwabeni and confirmed the facts contained insofar as they relate to matters concerning me. And that is also dated April 2024. The third annexure, to confirm that I'm literally and figuratively on the same page as Your Worship, that should be, it should start with for immediate release.
Yes.
Thank you. It's dated 31 March 2024 for immediate release. Statement issued by Mandla Glaba on behalf of the Glaba family regarding Mfundo Glaba in an ongoing court case. Since the name of our brother Mfundo Glaba was recently mentioned in court in the murder trial of Mr. Tabela Mochwana and the late South African music icon Kieran Jarrett Forbes, popularly known as AKA, there has been much speculation in the public domain about the reason for one payment that was mentioned by the prosecution. As the Glaba family, we acknowledge the gravity of the situation at hand and the widespread interest it has garnered. We wish to express our unwavering faith in the South African judiciary and affirm our commitment to cooperating fully with all arms of the state in the pursuit of justice. In light of recent developments and the allegations directed towards our brother Mfundo, we wish to clarify the following. Mfundo is an adult and is a successful businessman involved in various sectors, including coal mining and the taxi industry. It is important to note that financial transactions between him and Mr. Grabeni were purely for business purposes. These numerous transactions over a long period of time can be verified through bank records and were neither unique nor isolated. We are concerned that the authorities have not yet approached Mfundo to share his side of the story. We believe in the principle of fairness and the right to be heard, and we urge that this opportunity be extended to him at the earliest convenience. It is crucial to understand that Mfundo has assured the family that he has no connections to any illegal activities, nor does he has any motive to engage in such. His business dealings are legitimate and transparent, having nothing to hide to anyone, least of all our law enforcement. The Gaba family take this opportunity to extend its deepest sympathies to the Forbes and Motrene families for the tragic loss of their children. It is a message we wish to extend to many South African families who lose their loved ones through violent crime that has afflicted our society. We express a sincere hope for a swift resolution to this case, allowing all affected families to find closure and healing. We appreciate the media's role in informing the public, and we uphold the right to a free press. We also request that our privacy be respected during this challenging period, and we commit to providing updates as more information becomes available and as appropriate. We stand united in our support for Mfundo and remain steadfast in our commitment to the rule of law. The family has since requested Mr. Jackie Shandu to respond to future media queries on its behalf. He can be contacted on, and it then gives a cellular phone number, Your Worship, and an email address. Your Worship will also note that with the affidavit of applicant number 4 are a number of still photographs, which I understand are taken from the USB, which is contained in the brown envelope. So, Your Worship, that is the affidavit of applicant number 4.
Thank you. Mr. Kwabeni, do you confirm the content of this statement read on your behalf into the record? Thank you. The statement is accepted into the record. It's marked Exhibit M. Will that be the case?
Indeed, Your Worship, that is the case for number 4.
Case for applicant number 4.
Worship, I was reading the affidavit in respect of applicant number 4. I'm just concerned with the paragraph at page 16, Your Worship, paragraph 48.
Page 16
Yes, Your Worship.
of the applicant statement.
Yes, applicant statement at paragraph 48.
Paragraph 48. I'm
Yes,
with you.
it indicates I annex here to my bank statement for the period in question, and this honorable court will note that the transfers are referenced to. I don't see any reference or any annexion in respect of those, the period that is being stated, my learned colleague here. It is the same issue from the respondents' affidavit that we have highlighted also, Your Worship, in respect of that. If my learned colleague can
Mr.
clarify.
Jefferson?
Thank you, Your Worship. My learned friend is indeed right, and I'm glad he's reminded me of that. It is true that there is no annexure attached, but my instructions are that same was referred to in the founding affidavit. So if the court wishes, they can simply ignore that sentence in the affidavit.
Am I understanding you to say that when I read paragraph 4, I should refer to the founding affidavit of the applicant, and I will find the statement there?
Yes, those are my instructions.
The biggest challenge, Your Worship, that we're having, we indicated as the respondents in our affidavit that There are certain periods, including January, February, March, that are excluded from the bank statement in our founding affidavit in respect of this matter. So if my learned colleague is saying that it is in reference to that, I don't know where to find that.
Yeah, but Mr. Kwega, the applicants have been alerted of this omission by yourself, particularly Mr. Kaba. They've been alerted. They cannot be forced to do as you wish.
Please is the court, Your Worship. Then we'll leave that for arguments.
Yes.
Yes, Your Worship. I can't take that point any further,
Yes.
and Your Worship will obviously have to take that point into consideration. But I think it's necessary to point out, and of course the state can subpoena the bank records in respect of applicant number 4, so they could go back as far as they wanted to. Thank you, Your Worship.
Okay.
I think there were dates that we arranged in respect of.
Yes,
complying with the state.
we have come now to the stage where the applicant's case have been closed. Are you, as the respondent, going to
We are going to reply.
Reply.
Your Worship. Especially now, there was a provisional admission of the DPP statement in respect of the extradition. We have to reply on those and further to the new evidences that have been arose from the founding affidavits.
We agreed on the date of Friday the 12th.
That is correct, Your
Does
Worship.
that date still stand?
But my understanding in respect of this matter is that the applicant begins.
Sorry, the
So there's been a
applicant?
founding affidavit,
Yes.
the state has answered, and there's a replying affidavit. In the normal sequence of events, that's where it ends. I understand, and I take the point, my learned friend has a valid point, that they wish to address the affidavit of Harrison, which Your Worship has provisionally allowed. But my submission should be that that is where they ought to be restricted to, in respect of yet another affidavit. They can't continually have bites at the cherry, because then we're going to respond to that. Because we start, we finish. That is the normal course of the flow of an application. Founding affidavit, answering affidavit, replying affidavit. As the court pleases.
I think Your Worship was saying the same thing, Your Worship, with all due respect. That's what the state is saying.
Any other different views?
Yes, just to confirm my learned colleague's submission, the state now is in a position where its supplementary is so circumscribed that it can't be carte blanche. It's confined, as my learned colleague has correctly identified.
Thank you, Your Worship. Mine is merely a comment. The state have been aware of and in possession of Advocate Harrison's statement from before any of the applicants became aware of it or before any reference was made to it. So they can't now say this is new. It's not new. They've been aware of it. They provided the evidence, or rather the submissions that are contained in that affidavit.
That cannot be correct, Your Worship. Our affidavit was not based on the affidavit of the DPP, especially with the order that was made by this court. Now they have alleged certain aspects from the DPP's affidavit. We have to reply on those aspects. That's what we are saying, because we never included that. It was the order of the court not to include anything from Swaziland. That's what we are saying, Your Worship.
But do you want to reply only on the aspect of the affidavit by the DPP, which this court has provisionally allowed?
Yes, Your Worship, especially with the law. The law, Your Worship, is simple, and we indicated before that. If they are replying on our affidavit, they reply on our affidavit. However, if they are raising new issues that are not contained on our affidavit, we have to reply, because we are the respondent. That is the law, Your Worship. Because they are supposed to be confined as well in their replies in our affidavit. So if they raise new issues in their replying affidavits, therefore we have a right to reply now on the new issues that they have raised.
Okay. No, there cannot be replies after replies and after replies. It cannot be.
With the amendment that we did, upfront, we informed the other party that we will be making this application. These are the issues we will convert to take everybody on board. That is what is creating the problem, because the state has not furnished us identifying, particularizing the things they will be answering to, so that it's not a blank check. My colleague is right. They can apply, but the law requires a case to be made out to supplement in the light of the fact that the proceedings are now considered closed, as my learned colleague for applicant number 4 submitted. In a nutshell, yes, the state has got a right, but it's not absolute in the sense that it's not there for the taking by the state. It does not necessarily mean that the state must be given that application. The state still has to make out the case, as we did in advance, say, these are the items. It's like an application to recall a witness or to reopen a case, because it cannot relieve the shoe of the pinch of the party asking to reopen. The same with the recalling, the presiding officers, they put us on tables as a defense. We can't have a second bite of the cherry. Put the items that if the application is granted for the recalling, this is what you will cover. Otherwise, you can't have a second bite of it. It is a nice to have, but legally, you have to make out the case.
I'll take a short adjournment to consider this one aspect and make a ruling thereof, which will then decide whether or not we have to sit again on the 12th of April, which is Friday, or we'll have to start making arguments or written arguments as we agreed and convene again on the 25th of April. I'll take a short adjournment, 5 minutes. On resumption, after an adjournment to consider the fact that is presented before court, I've applied my mind and to my understanding, the request by the state to reply is based on the statement or the affidavit by the DPP, which was provisionally allowed by this court on the last appearance. This court is still going to assess and receive arguments as to this matter. There is therefore no need for the state to reply on that one aspect and that one aspect alone. So, looking at the nature of the proceedings before this court, the agents thereof, and the need for this matter to be finalized as soon as it is practically possible, I think to allocate another day or date for replying affidavit on this one aspect, which aspect can be covered by way of argument, I think it would amount to a waste of time. So I am not allowing the other date, and I am of the view that it can be covered and be properly addressed by way of an argument by the state.
Sir, please,
Does this therefore leave us to the date of the 25th of April for addresses? Okay. Should we therefore postpone the matter to the 25th of April? Applicants to please rise. The matter against you is now postponed to the 25th of April. This would be for addresses and arguments by your respective legal representative and the state. There would be exchange of documents, I believe, and the state and the defense agreed on the dates when they would be exchanging their arguments and supply me with the copy thereof. So, but the matter is adjourned until the 25th of April. Thank you.
Sorry, maybe I misunderstood, but I thought the 25th was the date by which we would exchange heads of argument only. That wasn't for argument.
That was not the agreement we made in chambers. The agreement we made in chambers...
Obviously you misunderstood that, Your Worship, because I will be in Cape Town on the 25th of April.
Mr. Tava, was that not the agreement?
There are dates upon which we will file the defense will file before and we file after. On the 25th to come and argue. That was the arrangement.
Mr. Mlojwa?
I concur with my learned colleague, but as my colleague says, he may have misconstrued the date.
That was my understanding. We had a meeting in chambers where we discussed this, Mr. Volmerans. It may be a mistake on your part, but that was the agreement.
Your Worship, I accept that it is my mistake because I don't have it in my diary for the 25th. I've got a date by which we have to file our heads of argument, but I didn't realize that the 25th was the day for argument, because I, unfortunately, as I say, will be in Cape Town.
It
So-
seems your learned friend has a solution, Mr. Jackson.
Your Worship, perhaps I can throw another spanner in the works. So as Your Worship knows, I wasn't here on the previous occasion. On the 25th, I'm expected at the Commercial Crime Court in Palm Ridge in Johannesburg. And I suppose why I'm on my feet is to ask about the viability of perhaps arranging another date other than the 25th, maybe even an earlier date, because we have finished the bail application earlier than we anticipated, because we factored in that the state may have been successful in the application for yet another affidavit, and that would have taken place on the 12th. So I suppose what I'm actually requesting from Your Worship, is it not possible we could move the timelines closer?
Maybe let's adjourn and have a discussion in chambers as to the dates. That in effect means, whatever it means, if we are to come up with different dates, the applicants can always be requisitioned if there is going to be a change of the 25th. Court will adjourn.
may we recall case number 23/2156 of 2024, State versus Lindoguhle Mkhwanazi and 4 others. We thank the court for the indulgence to adjourn the matter for a short period so as to arrange a further date. We are in agreement that the date of the 2nd of May seems to be convenient to all the parties. However, as officers of the court, we are alive to the fact that at all relevant times you have to assist the court at best as one can. In the short adjournment that we had to arrange another date, the board counsel for the state had to understand the legal consequences of the ruling that the court has made. We respect that the court had to make a ruling and respect that that ruling has to stand to all the parties. Now, the difficulty then is unfolded in the following. The applicants in their replying process requested the court to allow evidence, which evidence the court provisionally allowed. And I will use this word provisionally because that is where the legal challenge then starts coming in. Now, in their replying affidavits, the applicants made reference in numerous of their paragraphs in their responses to this provisionally allowed evidence, which we all seem to agree is new evidence. Now, the state, respecting the ruling of the court, accepts that the court is of the view you can merely argue or make any reference to this newly admitted evidence in your arguments. If we accept that as the parties, it therefore means the state has not been given an opportunity to reply to this new evidence because it is provisionally allowed. The state is allowed only to argue on its admissibility or not. If the court at the stage when the evidence is argued accepts it, not provisionally, and said, I'm allowing this evidence. If the court then makes that ruling, the court is not favored with the state's response to that now admitted evidence, whereas the applicants have had that opportunity. They have indicated whatever they want to indicate in their replying affidavit on this provisionally allowed evidence. Now, that becomes a problem. Simply to put it, we argue, you make your ruling that whatever I provisionally allowed, I'm now accepting it as evidence. One party would have commented to that evidence, but the other did not. Now, if we are at that stage of the proceedings, I'm not too sure whether is the court now saying, let's first argue that. Upon me making a ruling that I'm allowing this evidence, will the other party who was not given an opportunity to comment on it be given opportunity or not? Aldi altera. Now the difficulty that we're facing now is the court is saying, argue on that admissibility. I will make an example. In a criminal trial, the state will say against the accused, this is now hearsay evidence, which I want the court to provisionally allow. The court will provisionally allow, and everybody will run with the case as if that evidence is provisionally allowed. But prior to the court making any ruling, the parties have to address the court on whether what has been provisionally allowed is now admissible. That is at the closure of the state's case. So that when the accused testifies, if he chooses to testify, he knows what kind of evidence he's facing. He's not facing a provisionally allowed evidence. He's facing either evidence that has been admitted or evidence that has not been admitted. Now, we are sitting in that situation where, as the state, we are saying, we accept the court's ruling. We will come and argue on the admissibility or not of this evidence. If the court says, I'm not admitting the DPP's affidavit, whatever the applicants have said about that, now it's pro non scripto. It becomes out of the record. But should the court allow it, then the court is only one-sided story, of which the alteram partem would not have been given to the state. Now, we're sitting with that difficulty, and as I said, as officers of the court, we have to raise these things as early as they can and not wait until the 25th to say, but here's a problem. Because when that is raised, it will seem as if the state is now delaying the processes and all of that. We are just raising it to say, let it placed on record. We accept the ruling that the court has made. However, come the 25th, when we have to argue, there are two legs that we have to argue. Firstly, the admissibility of this evidence, and what are the consequences if it is admitted, basically. So I wanted to place that on the record and hear what was the court's and my learned friends' view of this legal, because it is a legal technicality that we need to address. As the court pleases.
Mr. Mdojo?
Please, Your Worship, first and foremost, I will start with an analogy. If we go to the High Court, we place on record we are disputing the admissibility of particular pieces of evidence. We don't have an onus to show that it is admissible, but the onus is on the state. My learned colleagues for the state will confirm. Before a trial within a trial can start, to determine and adjudicate on the admissibility of the evidence, the defense will have to stand up and state the basis upon which the admissibility is being challenged. Fast track to this matter. At the first appearance, for number 1 and number 5, Mr. Dlamini says, we understand we bear an onus to show the existence of the exceptional circumstances. Can the state please give us the grounds so that from the word go, when we show the exceptional circumstances, the existence, we also incorporate the accountability to the grounds that the state would have raised. The state stood up and said, no, the right time will come where we will tell you the grounds. So as a result, it's against that background that in the replying affidavit, we state how one had to rely on State versus Dlamini and other cases by the Constitutional Court. We had to give just a generic information that we thought would be able to tilt the scale in favor of the applicant. Up until the answering affidavits came. And then when the answering affidavit is presented by the state, Then the grounds are provided. Then we filed the reply. And then it's a very technical aspect, Your Worship, because now there is a number of legal instruments that are guiding this court. The norms and standard by the Office of the Chief Justice, that the judicial officer is imbued with the responsibility to ensure that the matter is handled as expeditiously as possible. And then the case flow management principle enjoins this honorable court to demonstrate judicial leadership by making sure that the right to finality in respect of the party who would have instituted the proceedings, in this instance, the applicants, because they are dominis litis. So now it's a quick fix that has now turned out to be a long-term disaster for the state, because we would not have been in this situation if the state upfront gave us the reasons. More often than not, in our bail courts, as we appear, the prosecutor will stand up and say, out of the factors in 60.4, all of them or few of them we are relying upon. Then we know what case to make. And then, Your Worship, the situation we are in is that there was, for us to be able to supplement and amend, upfront, in advance, we had to show all the interested parties that this is what we were going to do in court. Tell us if there is an objection. And then procedurally, it's a pure procedural issue. That aspect was not forthcoming on the part of the state to say, Your Worship, mind you, the record still shows that there was further affidavit that was filed by the state. Upon the state realizing that they had to supplement few issues, even though the state calls it a further affidavit, but in law, a right take for it will be a supplementary affidavit to supplement issues which was not objected to. So which means the state is given an opportunity to supplement again, having been granted an opportunity to supplement even though the state had not closed its case. So my humble submission, Your Worship, is that this issue, as the court has correctly stated, in our heads of argument, both parties have to set out clearly why a provisional order should be reversed or why it should be made permanent, and then any other issues incidental to that determination, and then the issue of the bail itself. So no prejudice will be suffered by any party. It's an issue that will be easily cured by the addresses. Your Worship, with bail application, I understand that the principles and rules are relaxed a bit. It would appear in this case, especially from the part of the state, there has been this accent, this insistence on the adherence and compliance with the procedure. So that is all, Your Worship.
Mr. Volmarans?
Thank you, Your Worship. I'm not going to repeat what I said earlier. I've already said it. But just to remind the court that this is an application. This is not a trial. And my learned friend for the state continually refers to this as if it is a trial. It's not a trial. This is an application. The applicant brings his application, the state responds, and the applicant then has a right of reply. They do not have that right. So, Your Worship, whatever my learned friend has said has no merit in it. This is an application. This is not a trial. So everything I said earlier about it, and hearsay evidence, Your Worship, is admissible. The source does not have to be disclosed. But we know where the source is. This is an affidavit which was in possession of the state. They knew about it because they supplied the information for it. So to now come and say, well, we've been taken by surprise or anything like that, Your Worship, has absolutely no merit.
Your Worship, I'm going to provide two explanations in reply, a long one and a short one. I'll deal with the long one first. And that is to endorse what my learned friends have said. The affidavit that seems to unsettle my learned friends for the prosecution is an affidavit deposed to by their own boss. And the fact that it unsettles them is unsettling in itself. That's the long answer, Your Worship. The short answer is, Your Worship has already ruled, and that should be the end of it. Thank you, Your Worship.
Clearly, my colleagues misunderstood my point. Definitely misunderstood my point. And I'll repeat it again. For starters, I do not understand the submissions by Mr. Volmarans and Mr. Jorgensen. The fact that the state had that affidavit does not change the fact that it became evidence in these proceedings. That is the bottom line. We had it in possession, so what? We had it, fine. But the issue of the matter, it now has to see light in these proceedings. When it saw light in these proceedings, it came at a stage where only one party has been given an opportunity to comment on it, and the other not. The basic principle, whether it's a bail application or whatever application, hear both sides of, so that you can make a proper ruling. The difficulty that the court will have is, should that provisionally allowed evidence become admissible, you only have one side that had commented on that evidence, not the other. That is the bottom line. Thank you, Worship. Just my apologies. Now, you will be requested by one party to attach a value to that evidence based on whatever they would have aligned in their evidence and their replying affidavit. Whereas the other party, you don't have the opportunity to listen to the other party and put value on whatever they're going to say. As a court, please.
I'm thrilled by the activity that is coming from both sides, the prosecution and the defense, and it makes one's mind to be activated on the legalities and principles attached to the proceedings. I've issued a directive ruling earlier on saying that I am not allowing the evidence coming from Eswatini court. I will refer to it as a directive. But in order not to close the door on the face of the applicant in their endeavor to reply to what the state have said, I provisionally allowed the evidence or the affidavit by the DPP. I think, in my view, that was a good move in that I did not close the door at the face of the applicants. I now know what is contained in their affidavit. I now know what their argument is, so I will be able to make up my mind whether to allow or not to allow the affidavit. Please believe me in that. I will make my mind. It will be an informed decision. I stand by the ruling I've made earlier on this morning. I stand by the ruling I've made previously. I will make a ruling later on when the time is ripe. Gentlemen, please rise. Due to unavailability of one of your legal representative, we have agreed in chambers that we have to postpone the matter to a later date, later than the date we have indicated to you earlier on, the 25th of April. The date now for arguments by both parties is the 2nd of May. So this matter is now adjourned to the 2nd of May. This is for addresses and arguments by both parties. We'll see you then.
Just before she happens, we then said we need to now arrange dates as to when the applicants file their heads and when we reply, in between today and the 2nd of
Moving
May.
from the 2nd of May
Coming
backwards.
backwards, yes.
Yes.
We don't need to be at court for those dates, Your Worship.
Yes.
Your Worship, we have, I'm looking at the calendar as it stands, today being the
8th of May.
8th of May. We have about 2.5 weeks. 3.5 weeks. May I request that my colleagues perhaps file on or before the 22nd of April? It will give them 2 weeks, and then we respond by the 30th of April. It gives us 1 week.
30th of April.
Now the court has to read this before coming to court. May I then shoot back, Your Worship, and say, the 18th, which is next week, the 19th, which is next week Friday, it gives them 2 weeks. 17.
That's the original date.
For yours. Mr. Volman is saying the 17th will suit him, and then we can respond the week after the 26th, by the 26th on Friday. Oh, there's not.
We actually arranged the 17th for us to file.
The 22nd suits me, the 17th doesn't. Maybe it should be on or before the 22nd. If my colleagues' heads are available before then, it won't make any difference.
I'm raising this because there are 5 applicants that will be filing, and we are only 2 to respond to the 5. Hence, we request at least that if by the 19th they would have filed, which is the next week Friday, they have the whole of this week and the whole of next week, and then the week thereafter, which gives us 7 days, the 26th, we can file.
You're not comfortable with that, Mr. Mlojo?
19 and 26.
Bishop, I will have to align myself to be part of the solution, not part of the problem.
That is your request, Mr. Volmerans. You say by the 17th you'll be ready.
Mine will be ready by then.
Mr. Gilling?
My principal will be ready by then, Your Worship.
So it is therefore agreed that the applicants will file their arguments on or before the 19th of April, which is next week Friday. The state will then have the opportunity to respond, and they will have to respond on or before the 26th of April. And then on the 2nd of May, the parties will gather in here for arguments. Will I be favored with the copies of your arguments? I did provide you in chambers with my
Yes,
email
I'm not sure
address.
whether my colleagues do have.
No, we don't have your email address. My learned friend has it. So he must.
We'll confirm
We
after the
will.
adjournment.
Your Worship, you will have our heads before the.
I will appreciate that.
We'll get the heads. Your email address.
Okay, thank you very much. The court now adjourns.
Mhla ka-2 May lona usuku enzobuka ngalo nina enkantolo. Before mhla ka-2 May ke abameli bazoshintshana ngama-argument babone ukuthi omunye nomunye uthini, ebese-ke ngomhla ka-2 sima phambi kwenkantolo ke baqophisane phambi kwenkantolo. You understand, Bishop?
Thank you. Court adjourns.